We're at 14, consider and take appropriate action regarding the district's handling of open records request. Wilson and Rose.
Okay, I have questions or concerns about the way that some of our ORR requests have been handled. The Texas Open Meeting Act specifically requires certain things to happen when those requests come in, and I have a concern that that process wasn't followed for a November ORR that came in. Specifically, if the act requires if you're going to withhold information because it's attorney-client privilege, you have to make that decision by the 10th business day, notify the requester, and then send them a letter. And this is a question toward our counsel. Do you know if on that November ORR request, if that was accomplished?
You're talking about the one from Greg Lamont?
It's the, yeah, I think that's the one, yes.
I can tell you that the time frame regarding the 10 business days did get away from me.
Okay.
I did reach out to Mr. Lamont. I spoke with him on the telephone. Well, let me back up a little bit. He was provided with a tremendous amount of documents that were responsive to his request. And I did find that there was, out of that large volume of documents, there was one document that was not provided to him that I believe was responsive to his request that needed to be provided. And then in looking at that, all the attorney-client privilege communication, which normally is not given in response to an open records request. So I reached out to him, talked to him on the phone, and said, I do have this other document that I need to supply to you, and then inquired with him about whether he was seeking the attorney-client privilege communication documents as well. He told me that he was not, so I drafted a letter that summarized our conversation and said, I'm giving you this one document, but essentially he's modifying his request that did not include any attorney-client privilege communication, so that information would not be provided. And then that was the end of the response.
A question: at what point did that happen in the cycle? I know after 10 after 10 business days, from my understanding from reading the act, if a request has not been made to withhold something after 10 business days, it's my understanding, according to the act, that becomes public and should just simply be provided, correct? Is that the way the act is written? Do I understand it correctly?
Well, unless you get some kind of response or clarification, if you seek clarification. And I believe there was clarification sought at one point from the requester. Isn't that right, Lori?
Do you know on or about when the clarification was sought?
I don't think it matters when clarification is sought. If clarification is sought at any point
But wasn't there clarification sought
for
that
which part
request?
of it? For the attorney-client privileged information? Or
No, just for the
Well,
documents in
I
general.
reached out to Greg and right away and asked him for an extension, which he was.
Oh, that's right.
glad
There was an
to-
extension
glad-
that was
glad to
that was
oblige,
sought and
which
that
I
was given
grateful
by the
for.
requester. That's correct.
I guess, and where I guess I disagree a little bit, according to the way I understand the way this is written, and I leave it open that I could be incorrect, is that after 10 business days, any information that was requested, if the Attorney General opinion has not been requested, it becomes public. It's my understanding after the 15th business day that a letter has to be written to the Attorney General. So it's my understanding the request happened November 23rd. So 10 business days would have been 8th or 9th of December. A extension was requested, which would have put it December 22nd, 23rd. But it's my understanding on the 10th business day, the requester had to be notified that a request was, that things were being withheld, going to the Attorney General. On the 15th business day, that a letter had to be submitted to the Attorney General requesting that that information be withheld, an exception be granted, and the requesters provided a letter stating that that occurred. I guess the problem I have with the timeline is if that letter asking for the clarification occurred, let's say in the middle of January, the information should have been provided months prior to that. And I don't understand how a action a month after a deadline can remove a responsibility of something that should have occurred a month in advance. Is that?
I don't think that that timeline that you put out there was correct because of the extension that was sought.
How long
from the
was the
requester.
extension that was sought? Was it 10 days?
I don't, Lori, do you know how long the extension was?
I got something I'd like to add to this conversation. I had a cup of coffee with the new town manager not too long ago, and I told him what I told all the people that applied for the job with us, is my number one priority for our new general manager is find a way to get along with the town. So when I had coffee with the new town manager, and I told him what I had told these candidates, he said to me, I think this ORR situation is out of control, and we should just be willing to provide whatever is asked for between manager and manager. Let's stop all this ORR. That was his opinion. I hope our new general manager will take that same opinion. I think all this squabbling about ORRs is not worth it.
And I would say with you, Director Hayes, I completely agree with you. The fact that a town official would have to make an ORR of the mud, or vice versa, I
That's
think it's
right.
ridiculous.
I do too.
But the only reason why I bring this up is I just want to make sure that if we do go down the path of going through this ORR process, that we abide by it, because the district could be put at risk if we're not meeting the letter of the law, if we don't have a suitable exception.
It
And
looks,
that's the only thing I would just want to make sure that
well,
we're.
from where I sit, Greg, it looks like to me you're trying to build a case against Paul, and I'm not interested in that.
Well, well,
Let's stay on top. Okay.
what I'm doing is I'm asking questions. This is the law that we have to abide by. To my knowledge, we can't pick and choose what law we abide by.
What class is recommending is let's have some interaction without all this formality, and then you want to argue about the formality. I don't see the purpose.
Just to summarize, I mean, there's a Texas Government Code 552, correct, that deals with the
Yes.
open. Okay, the bottom line is there's an agenda item on here about open records. All we have to do is make sure, or do a better job if we didn't do it, is to follow that 552. End of topic.
Like I said, one thing I would
that
like
okay?
to say too, I want to make sure the board is aware. Lori, what was the total number of pages of documents that were provided to the requester in response to that open records request? Lori, do you know that
It's
number?
close to 4,000.
Close to 4,000 pages.
How many pages were withheld?
3,999.
It was, I don't know that exact number. I don't know if Lori
Yeah, I'm
knows
just
it either,
curious
but
if she knows.
I can tell you it's very small percentage compared to
30.
what was provided.
I'm sorry,
30?
30? Okay.
30 pages withheld out of 4,000.
Yes.
Yes, yes,
Go ahead.
that's what we're talking about.
As I look at this situation, we have a set of statutes that are required to be followed. From what I've heard, I get the distinct impression they weren't followed. In that, the timeline wasn't followed. Was there ever a submission to the Texas Attorney General under that request?
No, there was not.